Hi, I'm Saladin Ambar. Welcome to the inaugural episode of This Moment in Democracy. This first episode was recorded on August 16, 2022. Joining me today is blogger and editor of SCOTUSblog, James Romoser. James attended law school at Georgetown University and upon graduating, practiced First Amendment litigation for 2 years in Washington, D.C. He returned to journalism in 2018 as an associate editor and legal affairs reporter for Inside Health Policy. He came to SCOTUSblog in June 2020 with experience as both a legal journalist and a litigator. James, thank you so much for joining us today.
Thanks so much for having me. Happy to be here.
Well, listen, we better dig right into this because there's been so much happening with the Supreme Court, as well you know. I thought we'd begin by reviewing a number of these key cases that passed this term, starting out with, surprise, Dobbs, which obviously overturned Roe versus Wade. If you wouldn't mind just sharing some initial thoughts about Dobbs and what the court's reasoning was behind its overturning of Roe and what it portends for the direction of the court going forward.
Yes, the Dobbs case was obviously the culmination of nearly 50 years of a conservative movement and opposition among conservatives to Roe versus Wade, which established the constitutional right to obtain an abortion. And it all came to a head in this case about a Mississippi law that bans abortion after about 15 weeks of pregnancy, which directly contravened Roe and some follow-on precedents, namely a 1992 case called Planned Parenthood versus Casey. And so when this case came up to the court, Mississippi initially simply said to the court that the justices could sort of uphold the Mississippi law, but somehow leave Roe versus Wade in place. That was the state's initial position. After Ruth Bader Ginsburg died and Amy Coney Barrett took over, the state kind of changed its litigation strategy and asked for a much more aggressive position, which was that the court should overturn Roe versus Wade completely. And as I'm sure all of your listeners know, just a couple months ago, we learned that the Supreme Court did decide to go all the way and fully overrule the constitutional right to abortion, which essentially paves the way for states to ban abortions or restrict abortions in essentially any way they choose. The reasoning of the court was essentially that the Constitution doesn't mention abortion, and when deciding what rights are covered by the Constitution, particularly these so-called unenumerated rights, rights that don't explicitly appear in the text, the court needs to look at whether the right is, quote, deeply rooted in the nation's history and tradition. And in the opinion by Sam Alito, the justices, the conservative justices, concluded that the abortion right was not deeply rooted in the nation's history, and therefore they found that Roe was, in Alito's words, egregiously wrong from the start.
I want to come back to Justice Alito perhaps in a moment, but first, what does this mean for abortion rights going forward? Are we going to see the kind of voting and, by their feet, if you will, by voters across the country, as we saw in Kansas, with states potentially overturning the overturning of Roe by supporting abortion rights? What does this mean going forward for women who are seeking an abortion?
I think that the Kansas vote was extremely telling and could presage a shift and a momentum toward people being motivated at the ballot box by the abortion issue. And I think we're going to see more of that in the midterms in November. Now, whether voters will be able to, preserve some degree of abortion rights at the ballot box will vary by state. The reason it came up in Kansas was there was a referendum on the ballot to undo a Kansas Supreme Court, a state Supreme Court decision. And, that scenario does not exist in many states, in many states, there are now full-fledged abortion bans on the books that were passed by the legislature, and there are no state Supreme Court decisions in those states that are impediments to those laws taking effect. And so I do think that the Dobbs decision is having a major impact on the campaign trail, and will certainly have an impact on voting patterns this coming November. But nonetheless, like, these red states have extremely conservative state legislatures, many of them, and have not been shy about enacting total bans on abortion.
Indeed. And I want to come back to Justice Alito, who you referenced earlier in your remarks, because this is obviously Chief Justice Roberts' court, at least ostensibly, given that he's the Chief Justice. But it seems that he is no longer the central pivotal figure any longer. Is it Justice Alito? Is he the person to watch on the court? How do you, for those of us who are maybe not, who are more casual viewers of the court, if you will, is he someone that we should be paying more attention to than usual? Or is there someone on the court who has regained the center that once had been held by Justice Roberts?
Yeah, so I would hesitate to use the word center, because I think the biggest takeaway from the term that recently ended is that this is an extraordinarily conservative court. And so even Chief Justice Roberts, who you say is no longer holds a kind of swing vote or median vote, because there are 5 justices to the right of him, even Roberts is a very strong conservative, all things considered. And so the fact that there are 5 justices, even more conservative than he is, tells you just how far to the right this court is. Now, who is the so-called swing justice, the median justice, the anchor justice, whoever we want to say? Right now, I would say that's Brett Kavanaugh. Brett Kavanaugh, because in some sense, some people have talked about this being a 3-3-3 court, and I disagree with that for the most part for various reasons. But you certainly have 3 liberal justices. Stephen Breyer will now be replaced by Ketanji Brown Jackson, who will join Elena Kagan and Sonia Sotomayor as the 3 justices who are often going to find themselves in dissent in the most ideologically salient cases. And then you have 6 conservatives, right? 3 of those conservatives are considered quite hardcore conservatives, I would say, and those being Alito, as you said, Clarence Thomas, and on most issues, Neil Gorsuch. And then you have 3 other conservatives: Chief Justice Roberts, Brett Kavanaugh, Amy Coney Barrett, who in some limited ways, and I want to emphasize limited, have in the past shown propensity to adopt slightly more minimalist decisions, to proceed more incrementally, to not go quite as far or move as fast as the sort of rock solid, triumvirate of the conservatives. And so that's why some people have talked about this in the past as a 3-3-3 court. However, that being said, what you saw this term was in all of the most divisive cases, you saw essentially a 6-3 vote, with, in particular, Kavanaugh and Barrett very willing to adopt pretty extreme positions. Now, the one slight exception is in Dobbs, where you actually only had 5 votes to overturn Roe versus Wade, and Chief Justice Roberts didn't really sign on to that part of the opinion, but he still would have upheld the Mississippi law and still would have rolled back abortion rights. That gets a little more nuanced. But in general, you did not see a 3-3-3 court this term. You saw a 6-3 court in most of the divisive cases. And so I think it will be important to see if that continues next term and in the coming terms. It is possible that folks like Brett Kavanaugh, maybe Amy Coney Barrett, maybe Chief Justice Roberts will sort of return to some more incrementalist impulses. But frankly, I wouldn't necessarily bet on that based on how the previous term has gone. The conservatives know that they have a supermajority. They know that they can move the law in new directions. And there's very little stopping them from doing that if they want to.
Well, and it seems as though these other cases that have maybe not gotten as much attention from this past term prove that point. We have, the Bremerton case with respect to religious freedom, New York State rifle case with respect to gun regulation, West Virginia versus EPA, regarding federal regulation and the administrative state. Those cases, pick one or two, if you would, to just kind of share any surprise or something that struck you about maybe a little bit of the lesser followed cases that came out of this term. Obviously, Dobbs is a historic case by any measure, but I think these clearly are pretty powerful ones as well. Any one of those or another jump out at you that, beg discussion?
Yeah, absolutely. I mean, any of the cases that you just mentioned could have been the big blockbuster case in almost any other term if it hadn't been for the abortion decision. They were all monumental cases in their own ways. And I just want to emphasize all three of those cases that you just mentioned, they were clear 6-3 splits. So we did not see any sort of moderating impulse from Chief Justice Roberts or Brett Kavanaugh in those cases. You really just saw the 6 conservatives all voting in lockstep in all those cases. So, I mean, I think, one of the cases that you mentioned is probably the other most important case in terms of its far-reaching effects is the West Virginia versus EPA case. This is about climate change and the ability of the Environmental Protection Agency to regulate power plants that produce carbon emissions. The procedural history is very complex. It goes back to an Obama era rule that never actually took effect. But without sort of going into the procedural machinations, at the end of the day, the court held that the EPA has limited authority to enact regulations meant to reduce climate change. In particular, what the Obama EPA had wanted to do was enact what it called grid-wide measures, essentially adopt rules that would move power generation away from coal plants and toward wind and solar and other renewable sources. And it relied on a section of the Clean Air Act as its authority to enact that policy. And what the court said in June in a 6-3 decision was that no, the EPA doesn't have that authority. And that's because the language in the statute wasn't clear enough to give the agency that authority. And so what the Roberts Court did in doing that was it really sort of adopted fully for the first time this doctrine called the Major Questions Doctrine, which is a doctrine that essentially the court made up. And what that doctrine says is that when an executive branch agency wants to make policy on an issue of exceptional importance, a quote unquote major question, Congress needs to speak very clearly, extraordinarily clearly in giving the agency the authority to do that. And here the court said, no, the statutory language about using the best system of emissions reduction wasn't clear enough. And so the EPA doesn't have the authority to really crack down on climate change. Now, that is not just going to affect the ability of policymakers to regulate climate change, but that concept is going to hamstring the ability of executive branch agencies across the government to make rules in all sorts of policy areas far beyond the environmental context. And this so-called major questions doctrine is highly controversial because it raises the question of who decides what a major question is. And the answer, of course, is just the Supreme Court.
Well, I think we're in the swing of these theories that seem to be not necessarily what we learned in social studies in the 11th or 12th grade back in high school or even in college. And I'm leaning forward a little bit into the future with respect to Moore versus Harper and this idea of an independent state legislature theory, which again is something that Hark, as a political science major and now professor, I didn't know about until very recently. Could you just share with us, as we maybe think a little bit ahead in terms of cases that are coming up, what is the independent state legislature theory, and how does it pertain to presidential elections? And what role does the court see itself potentially having in shaping how presidents potentially get elected?
Right. So the independent state legislature theory is a theory in election law. And supporters of the theory believe that the Constitution, that a particular clause in the Constitution gives near total authority to state legislatures to make the rules for federal elections in that state. And this would be for both presidential elections and for congressional elections within that state. There are actually two related clauses in the Constitution. They both sort of give rise to both types of elections. And the language of the Constitution, just so your listeners know, is essentially that the state legislature shall set the time, place, and manner of these federal elections. And this theory has arisen because in some states, and in the state at issue in the case that the justices will hear this fall, North Carolina, state legislatures have taken some pretty aggressive actions. So, for example, in North Carolina, the Republican state legislature drew a new congressional map that was highly gerrymandered and highly favorable to Republicans running for Congress in that state. And there were legal challenges to that map. And when those legal challenges went to the North Carolina Supreme Court, the North Carolina Supreme Court said the map violates the state constitution, the North Carolina Constitution, because according to the North Carolina Supreme Court, which typically would be the final interpreter of the North Carolina Constitution, the state constitution prohibits political gerrymanders. And now the Republicans in North Carolina have come up to the US Supreme Court, and they've said that the North Carolina Supreme Court really has no power to toss out that congressional map because the US Constitution confers total authority on the state legislature to conduct elections, to draw maps, and really the state courts just have no role in providing any oversight of what the legislature does, what sorts of election policies the legislature makes. And that's quite an aggressive stance because there are really no other areas of law in which we say that a state legislature has complete unfettered authority without any oversight from other branches of state government. But that's what the state legislature, the independent state legislature doctrine says. And it could have very broad ramifications for upcoming elections if the Supreme Court endorses this theory, because, as I just alluded to, it will mean that state legislatures will be unchecked by theoretically the governor in the state. So there's even a question of whether a governor would have the ability to veto a state legislature passed voting law. Because if the state legislature is solely in control of running the elections, then that doesn't seem to leave a place for the governor or for state courts.
Again, I think you said it well when you alluded to the idea that absent the overturning of Roe by Dobbs in the Dobbs decision, this and other cases would have be highlighted in an unprecedented fashion. The prospect of this independent state legislature theory holding is something certainly to watch. Obviously, we're broadcasting this podcast out of Rutgers University, and higher education is always top of mind. Going forward, affirmative action seems to be very much threatened, potentially, I would say. I hate to put you in the position of being a prognosticator, but what do you suspect will happen with regard to affirmative action in higher education as the court takes up this issue in its next term?
I think affirmative action is very much in jeopardy based on what we know about the makeup of the Supreme Court and what the justices have written about this issue in the past. There are a pair of consolidated cases, one involving Harvard University, the other involving the University of North Carolina. And both are challenges to those universities' use of race in the admissions process. And the cases will be heard on Halloween. So I guess happy Halloween. I don't know, trick or treat. I don't mean to make light of this issue because I think that it is going to be a very closely fought case. There have already been dozens and dozens of amicus briefs filed in these cases. And, I never like to make predictions, but I think that it is very difficult to find 5 votes who would be willing to uphold affirmative action on the current court. And so I think, the test will be whether there is whether the court comes to some kind of narrow decision or a very sweeping decision that essentially outlaws the use of race-conscious admissions, writ large. And that remains to be seen.
Well, James, this is a bleak outlook for progressives, to be sure. Obviously, conservatives are living in a kind of dreamland in terms of what they've been fighting for the last 40 or 50 years. But for progressives, this is a rather dark time with respect to the Supreme Court. And yet there seem to be very little, options available moving forward. There has been some talk of President Biden potentially, through Congress, expanding the court. There's been some talk, for example, of Clarence Thomas being removed, impeached, based on his wife's involvement with respect to actions tied to the January 6th insurrection. There have been talk of term limits. Are any of those options plausible? Do you see any, constitutional remedy for how progressives might transition, short of, just the sort of the natural process of politics, a 20, 30, 40-year cycle of conservatives on the court? Is there any way progressives get to reshape the nature of the court, short of, expansion, removal, et cetera?
Well, I think there are 2 really good questions there, and I think the answer is different to each of them. So I think the question of whether there are conceivable remedies for liberals and Democrats in Congress to employ if they don't like what the court is doing, the answer is yes. They could pass a law that adds seats to the Supreme Court that doesn't require changing the Constitution. Congress has done it before. They could simply pass a law and do that. Congress very likely could impose a form of term limits on Supreme Court justices. This is an issue that has gotten some traction in recent months. Congress certainly has the power to impeach a justice, and you mentioned Clarence Thomas. And so Democrats in Congress could try to move to do all those things. The second question is whether, as a political reality, any of that is likely to happen. And I think it's almost certainly not going to happen, at least not in the short term. I don't see, and again, I'm not a political scientist, I'm focused on the Supreme Court, so take this with a grain of salt. But based on what I see, I do not believe there is a lot of political will right now for the Democrats to expend capital doing that. It would be a massive fight to enact any of these measures, these court reform measures. Biden has shown absolutely no interest in, poking this hornet's nest. As a candidate, he said that he was opposed to expanding the court or enacting term limits, and he's basically said nothing on the issue. As president, even in the light of decisions like Dobbs. So there have been bills filed in Congress that would, establish some of these reforms. I don't see them going anywhere, at least not in the foreseeable future.
Thank you for that, James. It seems to me that, back to Justice Roberts, that the court, to his way of thinking, has probably taken an institutional, reputational hit. How would you assess the reputation and prestige, such as it is, of the court today? A once hallowed institution. Where does the court stand in American life right now as we think about this moment in democracy?
Well, there's no way to put it other than to say that, public confidence in the court is at a historic low. Numerous polls over the past few months have showed that disapproval rates among Americans for the Supreme Court are higher than in the history of these polls have been conducted. And, what does that mean for the future? What does that mean for the institution? Will it bounce back, or will it lose legitimacy in some kind of very permanent way? I think time will tell. I don't know the answer to that. I will say, living in Washington, D.C., even just optically, it's a very stunning image. You go down to the court these days, and it remains surrounded by this very tall security fencing that they put up during the abortion protests in the spring and summer. The court remains closed to the public. And it's just, it appears to be this isolated institution of 9 individuals who have sealed themselves off from public perception in many ways. And their approval rating, I think, has obviously taken a major hit, primarily because of the decisions they handed down, which are unpopular among a majority of Americans. And Congress has not shown, as we just talked about, a willingness to step in and sort of enact any reforms. And so I don't know what this means for the institution, but but I do think the institution has very much taken a hit. Yeah.
Well, I'm afraid we're going to have to close on that rather somber note. But before we do, James, if for folks who want to follow you on Twitter or anywhere else, could you just maybe give us your handle very quickly? That would be great.
Yeah, sure. I'm on Twitter at James Romoser, JamesRomoser. And I encourage everyone to take a look at SCOTUSblog. We've been having a bit of a slow summer because the Supreme Court has been pretty quiet. But come this fall, when the justices are back on the bench, we will be covering every case fast and furious, as we always do.
Well, we're really appreciative of you being our first guest. So thank you for taking the time out this day to share your thoughts on the court and past and future cases. We really appreciate it. And to our audience, thank you for joining our conversation. The Eagleton Institute of Politics is a nonpartisan research unit of Rutgers University. This Moment in Democracy was made possible in part by the generosity of Eagleton supporters. To support our work, click the link in the description. Learn more about the Institute by visiting eagleton.rutgers.edu, signing up for our emails, and following us on social media.